Court of the Virgin Islands, Your Honor, and give attention. For this court is now in session. The Honorable Reese S. Hodge, Chief Justice. The Honorable Maria M. Cobret, Associate Justice. The Honorable I. Arlington Swan, Associate Justice, presiding. God save the United States, Territory of the Virgin Islands, and this honorable court.
Good morning, everyone. Here we will start and follow the calendar. So we will start with the first case, Cajuste versus the People. This is number 7 of 2023. On a Christian.
Good morning, Your Honors.
Good morning.
Adam Christian, appointed counsel for the appellant Jacques Cajuste. I'd like to reserve 3 minutes for rebuttal.
Very well, you may proceed. So let's make sure we've got the time set. Okay, you may proceed.
Thank you, Your Honors. Good morning again. Adam Christian for the appellant Jacques Cajuste. The underlying theme of Mr. Cajuste's appeal is the principle of due process in two concepts. One, pretrial delay, which should have been addressed, was not addressed, and had it been properly addressed, would have led to the dismissal with prejudice of this action. There should have never been a trial. Secondly, this court has noted in Blyden versus government and others that any time there's a conviction based on insufficient evidence, that's a violation of due process. The briefing addressed the pretrial delay first, but that was done because of the order in which motions were filed, observing the principle that the court avoids constitutional issues if they don't have to address them. I'm going to deal with the trial errors first. With respect to the sufficiency of the evidence, the trial court should have granted Mr. Cajuste's motion for judgment of acquittal at the close of the government's case. Mr. Cajuste, or rather the record demonstrates that the people never put on any evidence that Mr. Cajuste did anything to Mr. Mano, the victim. Murder requires an unlawful killing with malice aforethought and premeditation, which means the government had the burden of proving that Mr. Cajuste actually unlawfully killed Mr. Mano. From the aiding and abetting perspective, the people had to prove that he had knowledge of the crime, took an action in furtherance of that crime with the specific intent to facilitate that crime. And the people have not produced any evidence of that. Yes, it can be proved solely by circumstantial evidence, but what the people put in the record is a bunch of disparate facts that do not connect in any way, shape, or form to demonstrate that Mr. Cajuste did anything to Mr. Mano. The people put on no evidence that Mr. Mano was ever seen in the area of the apartment where the incident took place.
How about the DNA?
Yes, there was some DNA of Mr. Mano in the apartment. In his statement, Mr. Mano acknowledged knowing the co-defendant, Ms. Stewart. But, the fact that there was some DNA in the apartment doesn't prove anything. This court has held by its already that mere presence at a scene isn't sufficient to convict on an aiding and abetting theory. The person must have actually done something.
Well, I thought that this was blood DNA in the hallway and in the bedroom where the victim was found stabbed to death.
Well, one, it was not demonstrated that it was in fact blood. the expert couldn't confirm that it was. He said it was
All right,
DNA.
But his report said that Cajuste is the source of the major contributor in the DNA of item Q27 and Q28, which is swabbed from the bedroom and the walls going down in the apartment.
Correct. But that's, if you were to accept that, that means he was in the apartment at some point in time. It doesn't prove anything about his actions.
Well,
Mere
that's not-
presence isn't sufficient.
That's not in isolation, though.
Well, that's my point, Your Honor.
That's not
Let's
in
look at the
isolation.
other
There are other
factors.
circumstantial evidence involved here. Incidentally, you raised the issue in terms of speedy trial, but am I correct that after whoever committed the dastardly deed, and when they approached him, after a while they couldn't find him? It is years later with the cold case unit that they found him, located him up in Pennsylvania. Is there anything should be attributed to the fact that he was not in the Virgin Islands? They couldn't find him?
No, Your Honor. They questioned him shortly after the incident, him being Mr. Cajuste. They didn't say he was
that the clock would start to run with someone who the police have been looking for, but who have absconded from the jurisdiction, and they perhaps didn't know where he was until they located him years later up in Pennsylvania. And that should not be counted against him as opposed to counted against the government filing?
Actually, no, Your Honor. And in fact, early on in this case, there was another motion to dismiss. There were several other charges that fell within the 3-year statute of limitations. The trial court granted our motion to dismiss on those that they were stale. The government raised the argument that you're raising now, and the judge found they hadn't put on any evidence that he actually fled. It's not a matter of just leaving. Everyone has the right to travel. That's a constitutional right. But they have to show...
If he's not here, how are they going to find him to have him arrested and charged?
Well, two things. One, we don't know because in 2008, the government stopped investigating, period. Two, before 2008, the government, and there's a police report in the appendix, they questioned Mr. Cajuste's sister. She said he's in New York. So they knew that they could go and find him. They just chose not to. And that's on the people, not Mr. Cajuste. He was never told he was a suspect, and so he traveled.
Well, how did the delay prejudice Mr. Cajuste?
Excuse me. Yes, Your Honor. The delay is twofold in particular. One of the pieces of evidence that the people relied upon was this supposed missing knife from Miss Brady's home. During the initial investigation in 2005, maybe 2006, Miss Brady, being interviewed by the police, said to the effect that there was a knife missing from her home, that she noticed it sometime around the time of the incident. Miss Brady passed away. The people then used Miss Brady's son to put Miss Brady's testimony into the record.
Well,
and we don't have any opportunity to cross-examine Miss Brady, the actual source of it.
Who wasn't it Mr. Cajuste who inquired as to what Miss Brady said about the knife? Wasn't Mr. Cajuste the one who elicited that hearsay?
Was it
Trial?
at cross-examination, wasn't it?
Yes, I used the cross-examination to undermine the people, because the people have
But
the
you
burden.
brought that out.
But no, the people had the burden of establishing personal knowledge under 602. And it's a
Well, what
proper
about her
use of
son?
cross-examination
What
to
about
say,
her son,
look, they
Mr.
didn't
Rodriguez?
establish the foundation.
Mr.
Mr.
Rodriguez
Rodriguez said specifically, the only reason he had any idea about this is because his mother told him. You can't penalize the defendant for using cross-examination to show that the people's foundation is lacking. The burden of the foundation
you use
stays with the people.
cross-examination to bring
It is
out-
not, it's not opening the door as you're suggesting at all.
Well, the government did not inquire of the son regarding where he got knowledge about the knife. The son testified that he went to his mother's house and he himself saw a knife in the bedroom where Mr. Cajuste slept. That's personal knowledge.
I have to.
A knife.
Your Honor, there are two brothers, Ishmael and Leopold. Leopold saw or said he saw a knife in the drawer. Ishmael never said that. Leopold was never shown the knife produced as an exhibit at trial. So whatever knife he says he saw in the drawer, we don't know what that was. Ishmael never saw the knife in the drawer. At least he never so testified. So there's no connection between those two, as you're suggesting, Your
Which one
Honor.
of them said during the trial, upon being shown the photograph, I think, of the knife, said that, yes, that's the knife that I saw, and this knife was did in fact belong to my mother, and she remembers seeing it in the drawer?
Not the drawer of the bedroom. That was two separate brothers with two separate sets of testimony. Ishmael is the one who was shown Exhibit 18 and said this is his mother's knife.
Right.
And he couldn't point out any identifying marks on it. It's just a very generic kitchen knife that one can get at Kmart. And that goes into my argument that that exhibit should never have been admitted because Detective Phipps never provided any foundation for it. The knife was presented to him in a Ziploc bag, just like in the pictures, Exhibits 18A and 18B in the supplemental appendix. That's how it was shown to him. There's no markings on it that have like an identifying case number. He never testified about a case number. He just was handed a knife and he said, yeah, this is it from the bloodstains. Now, mind you, he saw this knife in 2005. He retired in 2012. He stopped investigating the case late 2007 to 2008. We're now in 2022. There's been no custodian to talk about anything about the knife, where it was, what had happened to it, where it came from. Again, there's nothing that was presented that ties that knife to this case other than to say, well, there's some bloodstains on it.
The trial court heard all of those arguments and was not persuaded.
Correct.
The trial court allowed the knife into evidence, and is not the reason that the trial court allowed the knife into evidence because it was for the jury to assign whatever weight to all of the evidentiary gaps that Mr. Cajuste was arguing before the trial court and is arguing before us?
And that's the general rule when it comes to that kind of foundation under 901. However, there has to be those holdings always present a situation where there's some sort of foundation. And in that case, yes, it's for the jury to weigh however they want to. But the jury is also instructed that they can only consider the evidence in the record. And if there's absolutely no evidence of any foundation, there's nothing for them to consider. And that's what made it error. This is not a case where the people put on some sort of foundation.
Let me see
They
it.
just pulled out a knife in a Ziploc bag and said, is this the knife? And the officer said yes. After a 15, 17-year hiatus. That's not a foundation for a murder weapon in a murder case. That's not how evidence gets admitted.
Okay, thank you. I think
I'm sorry,
your
my time
up.
is almost up.
It's over.
Oh, I'm over. My apologies. I will yield the stand. Thank you, Your Honors.
You may proceed.
Good morning, Your Honors. May it please the Court. Assistant Attorney General Ian Clement on behalf of the people. There are four areas that I want to to the sufficiency of the evidence.
Maybe you can speak up a little more. We're having some trouble hearing you.
There are four areas I want to focus on with respect to the sufficiency of the evidence.
You know you can speak louder than that.
I want to focus on the blood in this case and the fact that Mr. Cajuste's DNA was found at the scene of the crime. His DNA was not just found at the scene of the crime. The serology expert from the FBI, Mr. Fletcher, testified that in his test on swabs Q27, Q28, that his blood was mixed with, or his DNA rather, was mixed with the DNA or the blood of the victim, Mr. Mano. So it's not just the fact of maybe his DNA was there at some other point in time. His DNA was there in a mixture with the victims, and in a mixture with the victims on two different walls within the crime scene. So that is highly probative of Mr. Cajuste's involvement in this crime. Second thing that I want to focus on is his cut. All right, so Mr. Cajuste was interviewed by the police. And when he was interviewed, he was nervous, he was fidgeting, and it was revealed that he had an incision on his arm that had been stitched up. That is a probable source of his DNA being at the scene. When he was asked how he received this injury, he stated that he received it a day later than when it was revealed that he was treated by Schneider Medical Center the day right after the murder. So he was seen at Schneider on June 23rd, 2005. He claimed that he was cut on the very next day. That was proven to be a lie because the custodian of records from Schneider testified, and the medical record was presented at trial and shown that he was seen the day before. So what we have here is not just the blood being present at the scene, but we have lies to the police which shows a consciousness of guilt. We have a cut that is a probable source of his DNA being at the scene. We have his leaving the jurisdiction, and although we couldn't get a flight instruction, the fact that he left the jurisdiction was a fact that was testified to.
How about his argument that the medical records, those nurses' notes should not have been admitted?
Well, Exhibit 30 was provided to the defense in discovery. They had that information already. There was an error as far as Exhibit 29, which they sought to have admitted. Exhibit 30 had more information in it. The defense had access to this. What happened in trial was the judge then redacted all of the information that was, Exhibit 29 had more information than Exhibit 30, and the judge redacted all the information from Exhibit 29, which was admitted, that was not contained in Exhibit 30. And so there was no prejudice to the defendant because the record the original record was lost in a hurricane, and this was the best possible evidence that the people could produce.
You know, isn't it amazing that when he showed up at the hospital with a cut that requires 6 sutures for stitching up?
Right.
And his blood or DNA was found at the crime scene, and the most you can have there is maybe a day or two differences. It's not strong circumstantial evidence that the cut might have left that blood at the crime scene. Now, he said that the reason why he was cut is because he had an encounter with a young lady, and they had an argument over perhaps some sexual favors or something.
Right.
But at the same time, we know one thing. We don't know who the young lady is that he had all this argument was, but we do know that with that cut, requiring 6 sutures, that could have left the blood that was found in the bedroom and down the hallway. Vis-a-vis what was he doing in that apartment?
Well,
Just in proximity to when the victim was killed with this knife that one of the Rodriguez brothers said, that's the same knife I saw in the desk, in the dresser drawer in the bedroom that he occupied in my mother's house, and I recognize it. There's not strong circumstantial evidence in terms of a nexus, particularly when he showed up with that knife. And the victim, the knife that was removed by Dr. Lundrum from the victim's neck seems to coalesce with what one of the brothers said was the knife that he saw in Cajuste's bedroom when he was renting from his mother who was staying there. Is not strong evidence, particularly when you hear, given the relationship between him and Mrs. Stewart.
right.
I mean, is there any question that they had an extramarital affairs? At least she had an extramarital affairs with him. Everybody saw them about the place.
Well, the people would agree with that. I mean, Leopold Rodriguez saw this knife, thought it was strange. Ishmael Rodriguez testified that afterwards the knife was no longer seen after the murder.
So whether his
I'm
mother...
sorry, Ishmael Rodriguez testified that what, sir? You need to speak up.
I'm sorry. Ishmael Rodriguez said that the knife was not seen at the home after the murder. The jury was not just viewing this evidence in isolation, it has to view this evidence in conjunction with the evidence with respect to Ms. Stewart, because they were tried together. And, you know, factoring in the relationship between the two, the fact that there's no reason for him to have been in this particular condo, this particular apartment. In his statement, Exhibit 15, he talks about knowing Mr. Mano and Mr. Mano knowing of him, but, you know, they're not friends. There was no reason.
What about the pre-trial, the pre-accusation delay? It took 14 years for the people to bring this man to trial.
Well, this court has...
How does the people explain the pre-accusation delay?
Well, this court has held that it follows the minority view, and that before the people have to explain the pretrial delay, the defendant must show that has suffered some sort of substantial prejudice. And whether you're looking at the minority view or a majority view, in this particular case, the defendant did not show that he had any substantial prejudice. In his moving papers, he talks about memories may have faded, witnesses may have died. Ms. Brady did in fact die, but, you know, as he stated here today, her statement was that, you know, the knife was missing after the murder. So at the very least, at the base level, that was inculpatory evidence and not exculpatory. And so there was no prejudice shown. And as for...
I'm sorry, you said at the very least it was what?
Inculpatory, not exculpatory. And so there was no prejudice shown, and this court has held that...
Sorry, if it had been, if what she had said was exculpatory, then there would have been prejudice?
Well, not necessarily, not necessarily, but what we're saying is that there's no prejudice shown whatsoever. That the only thing that he has shown is that she said that the knife was missing. That doesn't assist his case. That hurts his case. It hurts the people that we're not able to present her at trial. As for Mr. Ishmael Rodriguez's testimony, that was properly admitted because the court found that it was just a source of his own personal knowledge that the knife was missing. I think in total, the defendant has a very high burden to meet here with respect to getting back to...
Sorry, the defendant has what, sir?
A very high burden to meet with respect to the sufficiency of the evidence. You know, he has to show that...
We're asking you about the pre-charging delay.
Right.
It seems to me that the government just stopped investigating The fact that he was away, he wasn't hiding, they could have found him,
Right.
but they did nothing. And, I mean, how do you justify, waiting 14 years to bring charges and expect that everything is normal, that no memories fade, nothing, that there's no prejudice? And I don't know, how do you explain it?
Well, the prejudice has to be substantial and it has to be shown by the defendant. And with respect to the 14 years, this court has held that you cannot substitute its own judgment for that of the police. And you want, especially in first-degree murder cases, for the police to bring charges when it feels it has enough evidence to convict. And it's not for the court to get into the investigative decisions of the police and the prosecutors. We bring charges when we think that we have the proper evidence to convict. And so in this particular case, a cold case unit was formed, and it started to look at some of the cases that were dormant, and it looked at this particular case and sent off for DNA, contacted Mr. Cajuste, brought him in, got his DNA sample, sent that off, and it turned out to be a match, and then he was prosecuted from there. But the delay in and of itself does not establish prejudice. The defendant has to show that and present some sort of evidence of some sort of prejudice. And so I think that was properly decided by the court. This court held in both Ventura and Rivera that we were following the minority review. The Superior Court followed this court's directive, and so it did not abuse its discretion. And with respect to the sufficiency of the evidence, based upon the whole panoply of evidence between Mr. Cajuste and his relationship with Ms. Stewart and the evidence presented against her and his presence, the presence of his DNA mixed with the blood of the victim in his entire bloody crime scene in two separate places, the knife cut on his arm, his evasiveness, his lies to the police all show a consciousness of guilt. And so it was fair, and the court properly found that any reasonable jury acting in good faith, or a reasonable jury acting in good faith, could find the defendant guilty of first-degree murder beyond a reasonable doubt. And it did not abuse its discretion by denying the motion for judgment of acquittal at the close of the people's case. And if the court has no further questions.
Thank you. Christian, you got 3 minutes.
Thank you, Your Honor. I have to reiterate, the testimony of Leopold was that he saw a knife in a drawer in April, about 30 days before the incident. He was never shown Exhibit 18, so there's no tie between whatever he saw and what was admitted. Ishmael never saw or never said he saw anything about in a drawer in any room. So again, even if you look at Exhibit 18, there's no tie between that and what Leopold saw. There's a huge gap missing there. There's no connector there, and that is the problem. I listened to counsel's argument on the sufficiency of evidence, and I'm still waiting to hear what it is that Mr. Cajuste actually did. Presence alone is not sufficient. And I questioned the presence evidence, as my brief pointed out. The serology expert should not have been allowed to testify in the way that he did, because his whole report was premised on a report that was done over 10 years prior. He simply incorporated that, looked at Mr. Cajuste's blood, which was only taken in 2016, and said there's a match. But without the prior report, his report doesn't exist. So essentially, the first report got admitted through the second report without any opportunity for cross-examination. On the pretrial delay, counsel was asked what was the reason for the delay. He couldn't provide one. And as I,
Well, let's step back a little and go back to the DNA report, that
Yes.
2006 report. What inculpatory evidence regarding Mr. Cajuste was in that report?
the inculpatory evidence from that report was the analysis done on all of the initial samples, including the victim's blood, without which you can't compare Mr. Cajuste's blood to anything.
When you say analysis, are you speaking about raw data, the data that the machine produces?
No. What happened in 2006 was there were a set of technicians who produced the raw data. Then there was an analyst who produced a report. That was in 2006, a full report. In 2017 or 2018, Mr. Fletcher got Mr. Cajuste's 2017, thank you, got Mr. Cajuste's blood. The technicians there did that analysis, and he properly relied on that. That's not a problem. The problem is, then he says, I looked at the 2006 report, I accept this report. He had nothing to do with that report, and says, based on this comparison, this is what I find. Well, you can't, the problem is, we didn't get a chance to cross-examine the author of the first report. Mr. Fletcher couldn't do that. So to allow him to testify that that report was fine when he had absolutely nothing to do with it, and base his entire conclusions based on the results of that report in terms of the comparison, which is the only way it's relevant, that was a clear violation of the Confrontation Clause. And that's what separates this case from all the other cases that this court has discussed. This is clearly a violation under both Bullcoming and Melendez-Diaz. And that is why it should not have been admitted.
Bullcoming and Melendez?
Melendez-Diaz, I believe it is.
All right.
How about the Williams case?
What about the Williams, right? What about the
Yes,
Williams case?
Williams.
Because remember now, Bullcoming and the other case came quite a bit early.
True.
But the Williams case, that is the authorship, that was in 2012. That was some years after. So apparently, Associate Justice Alito took a vastly different view in Williams versus Illinois than Justice Scalia took in Bullcoming or in Crawford.
That's correct. The critical point there is that Williams was a plurality opinion. It doesn't have the precedential value of Bullcoming and Melendez-Diaz and Crawford, which were majority
what you mean
opinions.
it doesn't have the presidential value? It's a United States Supreme Court case.
Right, but there's rankings in terms of their precedents. Plurality means you don't even have a majority of the court agreeing to the principle announced.
What difference does it make? It is presidential.
Well, it has some precedent, but it can't be weighed over a majority opinion. In this case, 3 majority opinions: Crawford, Bullcoming, and Melendez-Diaz. Those are all majority opinions. So those have to take precedence over Williams.
Well, this is the first time I've heard of the issue of Supreme Court cases that's a majority. In other words, if it's 6-3 or 5-4, what difference does it make? Does it have a certain ranking?
Because 6-3 and 5-4 are all majority opinions. I believe there was only 4 justices that signed on to Justice Alito's Williams opinion.
Suppose we have 4 plus 2 concurrent opinion that sides with the other 4.
Your Honor, I did cite. I'm sorry to talk over you.
It was a
I did
plurality
cite to a
opinion.
case in my brief that talked about the rankings and that a majority opinion has ranking over a plurality decision, and that you have to give, because the majority opinions are what are completely binding. They don't outrank or they do outrank a plurality decision where the Supreme Court can't get a majority to say
What did
this
this court say in Saldana?
This court in Saldana, well, let me step back and answer that this way. Saldana has a very different factual scenario.
Toxicology report.
The toxicology report, that's all done. You can follow that trail very easily, and it's not separated by 12 years and two separate complete reports that are independent,
Well,
done by two different people.
Let's go back a little bit to Mr. Fletcher's use of that 2006 report. Did Mr. Fletcher not test the DNA from the 206 report himself?
That's not my recollection. He said he looked at the report and said he didn't see anything wrong with what was done. I don't recall him saying he actually performed more tests, and I don't know that the DNA would have been preserved that long. Certainly they would have had to testify about how it was preserved, and none of that was presented, if that could be done. That's a scientific issue. There's no record that that was done certainly wasn't presented at trial for the jury to consider.
Okay, thank you.
Thank you, Your Honors.
The matter will be submitted and
Very good. I have no further business today. May I be excused?
you're free to leave.
Thank you.